So, Asha, can judges force the Trump administration to comply with their orders?
It's complicated. I'm Asha Rengappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm the author of the Freedom Academy Substack.
And I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And we're here to help you understand topics that can't be boiled down into a soundbite or a scheme.
Wow. Well, for our first topic, Asha, I think we've got something that I personally have been watching unfold on the ground here in Chicago.
Yeah, this is not in my backyard. That's happening in your backyard, basically.
Yeah, and I will just say, kind of before we get into the meat of what we're going to discuss here, that it really has had a pretty substantial impact on our community. I know people who have been indicted. I have been approached by people who've been indicted to represent them, and I'm not talking about vagrants or something. I'm talking about people who own businesses, people who are important members of the community because they were exercising their First Amendment rights. They got caught up in now with federal criminal actions taken against them. But I think it's fair to say also, Asha, there's been sort of a bipartisan reaction here to some of the very aggressive tactics that have been used, and I think unlawful, unconstitutional at times tactics taken by the Trump administration in their ICE and CBP operation here in Chicago.
Yeah, so we've been seeing a lot of these images on the news of things like tear gas being deployed. I think there was the one video of the priest that got hit with some, rubber bullets or something like that. So these are all people who are basically out peacefully protesting, as far as I could tell from the videos. But ICE is basically saying that they're justified in using these more extreme levels of force. And, I have to say, as a former law enforcement officer, we'll talk about the Department of Homeland Security's use of force policy. I'm not seeing it in at least the clips that are coming up on the news.
Yes. And just to be clear, some of those clips include, for example, ripping a woman. And when I say, woman, I'm not talking about, Ronda Rousey here. I'm talking about a middle-aged person who doesn't appear like very athletic, ripping her away from a car and throwing her on the ground at one point, taking, families away, literally ripping children away from their parents and taking the parents away, from the arms of the kids. And so on. Just absolutely horrific images that are very difficult to watch, in my opinion. Just challenging images to observe. And so, what I think, the reason I started there, and the reason I'm talking about what happened, Asha, is because, in my opinion, it really gives a backdrop for a bigger issue here of what can the legal system do about this? And I will say that all around this area, people have been asking me, and in the Chicago area, do the laws matter anymore? What can the law do about this? And that has been a challenge. And that central question is really at issue here because you have Mr. Bovino strutting around the streets of Chicago in a uniform, as if he's sort of a conquering general like George Patton or something.
Yeah.
And I mean, they're literally, he's got an entourage of folks in masks around him. He's the unmasked one, going and taking photos in front of tourist locations, but also terrorizing schools and businesses. And what I watched in real time are judges, federal judges I know, trying to grapple with what they can do in the face of that. And it has really been remarkable to see.
Yeah, and I think there are just a few different issues. I think we're going to talk about the separation of powers issues in terms of what can the judicial system do with the executive branch, but I think there are also policy issues that are underlying this in terms of like just larger ones that have been around for a while in terms of militarizing police forces by giving them some of these uh, you know weapons. And I mean, this has been going on for a while where police departments have basically become, military tactical units. They literally have military gear. And the other word that you use, terrorizing, I think is important when we talk about the deadly force policy, because, it gets to what is the purpose of using this kind of force in this domestic law enforcement setting. And are these tactics being used truly for the purpose that you know the use of force and even deadly force is allowed for domestic law enforcement. But let's maybe start with where this is right now, because this is a case that was filed, or there was a lawsuit filed in early October by people who have been affected by this. So journalists, newsroom groups, protesters who alleged that these federal immigration agents were using violent and illegal methods to basically silence them, and that this was an infringement of their First Amendment rights. And the judge in this case, Sarah Ellis, issued a TRO after that lawsuit was filed, so a temporary restraining order, where I remember this was notable because she wanted Bovino to come and report to her every day, because she felt like, she was saying that it did not appear to her that the use of force that was justified. And she wanted, and I think in particular, the use of tear gas that Bovino had said, had been necessary, and his folks were acting in an exemplary manner or whatever. But she wanted him to report every day, I think at like 5 p.m. on what tactics they had deployed. And she had that went up to the Seventh Circuit, and there was a writ of mandamus that was issued against the judge that particular aspect of her TRO violated separation of power. So we're already, before the most recent order came down, already in this tension.
That's right. And just to give some background here, there was a lawsuit that was filed by various groups in Chicago against the Department of Homeland Security, seeking, you've used the term TRO, that's temporary restraining order, and a preliminary injunction, essentially emergency orders, you could think of it that way, by the court to stop something that was happening that was unlawful, that you couldn't wait till the end of the lawsuit to figure out, because there was some harm that couldn't be undone, that was essentially being engaged in. Now, Judge Ellis, by the way, unlike you or I, not somebody who has experience in law enforcement herself, more someone who has a background in civil law, she issued orders originally, to her credit, and trusted that DHS would comply with them. And what she found was she was receiving reports from the plaintiffs that
They weren't.
they were not. They were not. And at times, there were video that were being shown that appeared to conclusively indicate that those orders were not being followed. So she brought in Mr. Bofino to speak to her, and she questioned him herself regarding his compliance with those orders. And it was quite a scene, Asha, because you literally had this guy in his uniform with his chest puffed out, strutting his way through the federal courthouse, immense amount of security around the federal courthouse for this guy being there, because obviously perhaps not the most popular person in the Chicago area right now, goes into the court, into her court, and has a pleasant conversation with Judge Ellis, in which he's like, yes, ma'am, no, ma'am, telling her what she wants to hear, and giving her the impression during that conversation that he's going to comply with her orders, and that he's fine coming every day to she's like, how about, she phrases these things in forms of questions and tries to navigate it. How about you come in here and kind of give us an update, and this and that, and sort of presenting it in a very friendly way. Like, okay, I'm going to try to work with you and try to, let's try to work together to solve this problem and comply with the law. And he gives her the impression under questioning that he's fine with all of that. And then the Department of Justice, of course, files something saying, hey, this she's overstepping her bounds. She says many times during the hearing, I know what my role is. I'm going to stay in my role and this and that. The Seventh Circuit, I'd say rightfully suggests that she's overstepping her role. But what I find interesting, Asha, in this interplay is that you had a judge who really wanted to try to ensure that the executive branch is complying with the law. And I could see that she was struggling in real time to figure out how to accomplish that in the face of someone who's telling her that the sky is not blue, effectively, just not telling her the truth.
Yeah. I'm not sure how you read. I mean, it's interesting. You think that he was kind of being very agreeable. And I agree that the words, because I only read, the words that were, as people were in the courtroom and tweeting him out and stuff. It sounded to me that he was like kind of dismissive, that the agreement was like, yeah, sure. Yeah, I mean, that was the tone that I was reading into his words, kind of knowing that he actually is going to still go do whatever he wants. That was my impression of his attitude and the swagger. Like when you combined that way, I mean, he probably knows that it was not going to be, it was, this administration does kind of a kabuki dance in court.
Mm-hmm. I agree with that, by the way. That's what I think we're trying. We're approaching the same thing from different angles.
Yeah. No, I'm just saying I felt that he was disingenuous.
I think that's right.
And
yes.
And the Seventh Circuit, it's interesting the wording that they used. I'm reading from their writ of mandamus, which is pretty rare, and that's kind of a smackdown, right? Of a judge's orders. The Seventh Circuit says, while this litigation presents very challenging circumstances, the district court's order has two principal failings. First, it puts the court in the position of an inquisitor rather than that of a neutral adjudicator of the parties' adversarial presentations. Second, it sets the court up as a supervisor of Chief Bovino's activities, intruding into personnel management decisions of the executive branch. And yeah, I mean, it is very challenging because it's one of these things where what is her remedy? Right? She's issued an order and she's put certain parameters on how Bovino and his minions need to act in order to be in compliance with the law as she sees it. And it's like if there's no accountability mechanism, then the only option is, I guess, the plaintiffs have to keep running back and saying kind of retroactively that they have not complied with it. I mean, I think this is the question of like, how does she ensure prospective relief?
Well, but this is why this is such an important topic for all of you who are wondering, hey, there's all these things going on, the shutdown's ending and there's new Epstein news and stuff. Why are we talking about this? Because I think it cuts to and gets to some of the most important problems of this time. And, just as a starting point to respond to what you said, I agree with you, Asha, that he was being disingenuous. I think that's a great word for it. But he was being non-confrontational with the judge. You called it a kabuki dance. He was being passive, not confrontational with her. He didn't say, you have no authority to direct me to do anything. Yeah. I am the executive branch. We do what we want. That sort of thing. We execute the laws, not you. He didn't take those positions there. It wasn't like a lawyer followed up as soon as he got off the stand and made those points to the judge to her face. She issued whatever order she issued. He made it seem like, okay, whatever. And then they, of course, went to the Seventh Circuit. And the Seventh Circuit, I think correctly said she's acting as a questioner and a supervisor here, not the traditional role of a judge. But that brings us to the point you mentioned, Asha, which is how do judges, I'll put it in a more pointed way.
Okay.
How do judges ensure compliance with their orders when litigants, particularly in this case, when the government doesn't tell them the truth and refuses to comply?
Right. In normal circumstances, the court has a power of holding litigants in contempt. And we've seen this happen once before in Judge Boasberg's court when he held a hearing when he believed that his orders weren't being complied with, and then at the end of that hearing found that there was probable cause that the government was in contempt. But then he got that got knocked out by the appellate court. So I think what's because of these like separation of powers issues, right? Like in other words, the government is not an ordinary litigant in this situation.
That's
because
right.
When the government is appearing in court, it's not only their actions which are at issue, it is their status as a co-equal branch. And I think this is what is creating a huge, huge problem, because this is not something, and people are like, anybody else. Well, it's true, but it's because the government is appearing as a representative of this branch of government.
Yes, and to put an even finer point on it or draw a connection, we've talked about in other episodes of this podcast that we're seeing an expansion of the court's the court is expanding executive power. Mm-hmm. And there's this sense that, hey, if you in any way interfere with how the executive is executing the laws, that is problematic. And I think that, gives a certain boldness. That is giving a green light to this sort of behavior, which has real consequences. And the reason I started there is because to me, this isn't like a theoretical conversation about like a legal statute. This is about like people getting beat up, people having tear gas shot at them and so on. People who are peaceful, just having tear gas shot at them for no reason.
Yeah. I also think that one of the hard things here is the instrument of accountability in the past, it seems to me, and you can tell me this having been a former federal prosecutor, is that the government needs to have credibility when it appears in court. Mm-hmm. And so there is, even when it's kind of appearing as a representative of this branch of government, and they and a judge gives them parameters on what it can do and what it can't do, the executive branch has normally had an interest, a self-interest in complying, maybe all the way up to the edge of what they, are allowed to do, but in complying because they understand that there are second and third and fourth order effects for all kinds of other cases that might be appearing in front of that judge and in front of other federal judges, etc. This administration does not care. This administration does not care and has been pretty explicit that the only court that they care about and the only court that they believe that has any authority over them is the Supreme Court. So these district courts are simply gnats to be swatted out of the way unless they rule in their favor. But if they rule against them or put any limits on them, and they don't feel that there are any consequences, right, of, that they will have to, their prosecutors may not be given the benefit of the doubt in other cases or whatever. They don't seem to care about that. And in many ways, the Supreme Court is telling them that they don't need to care about that. The Supreme Court has, in other instances, itself rebuked lower courts rather than rebuking the government. So I think there's a structural issue here that these branches are not behaving in the way that they normally have, that has allowed this kind of tension to be resolved in other contexts.
It's it's interesting, Asha. I've been thinking a lot about historical parallels and trying to think if there is one in our nation's history to this. And really, what's come to mind is a lot of things that I, and I'm sure you also learned about in law school, where you had state governments that were violating the Constitution in some way, and you had federal courts in the civil rights era trying to supervise state and local governments who just were refusing to comply with their orders. And there was a lot of criticism for how courts acted in that circumstance because in many ways, they were viewed as doing the same thing, right? Like you have a court supervising an entire school system or prison system or et cetera, because there's violations of the Constitution or federal law. And I think it's remarkable that now we're full circle, but it's now the federal government, not the state government.
Yeah. And we've talked about this before in the context of the presumption of regularity. Like there's been an interest in preserving that good faith, that institutional capital, let's call it, that the executive branch had, and they are willing to squander it. So anyway, this judge got a writ of mandamus and said, no, you can't, do this supervision. I don't know. I mean, I see the point, but also I'm not sure that it's necessarily out of bounds to request a report back. I don't know why that would be so, far out. That's not being an inquisitor. That's just asking for facts.
It's interesting, Asha. In other contexts where you don't have the federal government as a litigant, it is not uncommon for a judge to ask for a report if things aren't progressing, like if the court's orders aren't being followed. Okay, you're going to be making a report to me, on X date, telling me, certifying that, whatever, you've complied with my order, whatever. And it's interesting here, and that's why you're right to say that the federal government or the executive branch is not a typical litigant, because they are being given a level of deference that another litigant would, a business, let's say, wouldn't get.
Right. So the temporary restraining order is temporary. And so there was a longer hearing last week in which Judge Ellis questioned witnesses, questioned Mr. Bovino, and then she issued a preliminary injunction on Thursday in which she said that the agent's use of force shocks the conscience. And she prohibited them from using riot control weapons. She told them that they have to give 2 warnings before they deploy any of these weapons or do these tactics. They have to wear body cameras. They have to have visible identification. And that is where things stand now. And of course, the Justice Department has now gone back to the Seventh Circuit to try to stay her injunction. Once again, saying that this violates separation of powers. They've also said that the plaintiffs in this case, and I think this is an interesting argument, don't have standing because, and they cite a case, and this has come up in other contexts before in the litigation in California. It's a case that basically says that you can't issue a preliminary injunction for a kind of speculative future harm, even if it's things that like the police have done in the past. In other words, these plaintiffs can't claim for sure that these agents are going to deploy riot control weapons against them tomorrow. So they don't have any standing to bring this. There's no injury for them to redress. They can only point to stuff in the past. And so that itself, I think, creates this tension, right? Because that gets to how do you stop future harm? If you agree with that, with that kind of framing. And then they disagree with her certification of the class, because she basically certified a class of people that are bringing this, that her ruling is, addressing. And they say that you have to address each plaintiff on their own because there's individualized harm for each plaintiff. And I thought that was pretty rich since, you know, there's no individualized suspicion for when they're acting on things, but they want there to be, you know, each plaintiff to have to bring their own case, basically.
Yeah, I mean, I will say that this is, in certain respects, not a typical class
It's
action
not.
case.
That's true. It's not. They're not as common. I mean, they don't have
Right.
like the kind of common features that you would normally expect from a class. But I think
Right.
it is hard for her to create something without certifying a class that can actually have broad-based relief. Otherwise, people do have to come in individually.
Well, that's the point. And we talked about this earlier. I'm trying to draw parallels because I think it's important for everyone listening to this to understand that these issues have come up in other contexts and they're going to come up again. And if you really want to understand the issues of why the legal system is struggling here, you're going to need to understand this. So,
it's the birthright citizenship case.
Correct. It's like, oh, every single person has got to come in. And or what about, remember the deportation? Every single person who's deported is going to have their own process.
Yeah. Mm-hmm.
And it's the same thing. And you can basically flood the system. Bovino's out there, they're not concerned about a court order saying they violated the law in the past. They're going to strut around and fire their tear gas and fire, pellets at, priests and whatever they're going to do. And they'll just drive around and then they're going to go to wherever they're going, Nashville tomorrow or Charlotte. And they're going to go do the same thing. And they'll rove around. It's cold in Chicago, so they got to go somewhere warmer to go, terrorize some other people over there. But the point being is they're not really concerned about court orders telling them they broke the law in the past.
No, and I think to distill what their argument is, you can't actually issue an order to stop us from doing anything in the future because you can't prove that we actually plan to do it in the future. And you can't hold us accountable for whatever we've done in the past because that's a separation of powers issue. That's basically the argument. And people have to come in. Every single person who claims that they've been harmed by us needs to get their own lawyer and come in individually.
Yeah, there's a formalism here, which I find fascinating, Asha. Respecting the fact that, okay, we have to have courts, but we want to make them toothless. It reminds me, in Star Wars, they had, if you recall, the Imperial Senate, and then they get rid of it in the first Star Wars movie. It's like, okay, we're done with the Senate. But they keep it around. We're going to keep the Senate around because we need to have stuff. Yeah, they're going to chatter, but they have no power. The emperor is going to actually do everything, but let's have them chatter about things. I guess it was like that in the Roman Empire as well, right? We have a Senate that has limited powers. And I think here it's like, okay, we can have courts and you can talk it. I'll even come into your courtroom and I'll have a nice chat with you about how I'm using tear gas. But then I'm going to walk out and do whatever I want to do and you can't do anything about it.
Yeah. And I love that you point out the formalism because it's interesting because this is an administration that is not observing separation of powers principles in anything that they're doing. When the executive branch is not complying with a court order, that's a violation of separation of powers too. Because guess what? They're supposed to follow court orders when they are usurping the power of the purse, which we will talk about in the next segment. That is a violation of separation of powers, but they're doing that in practice and then arguing these principles, these very rigid, this very rigid idea. And the thing is that ultimately separation of powers only works. Separation of powers is this idea that it's not just, that each branch can't tell the other what to do. Is that there's core functions in each that in order for that branch to be able to function and in its most robust capacity, there are certain things that belong that are kind of essential for that branch that can't be interfered with, right? And we talk about this a lot when it comes to the executive branch, national security and foreign affairs and these kinds of things. Well, one of the essential functions of the judicial branch is that it must be obeyed. That's literally the only way. There's no enforcement mechanism for the courts. And so when the executive branch isn't doing that, they are essentially aggrandizing the executive branch at the expense. It's no longer a co-equal branch. They are not treating it as a co-equal branch. They are essentially usurping its powers. And then it's just very rich that then they go in and argue that this is a violation of separation of powers in the other direction.
Right. And really, to put a finer point on it, one thing we've talked about in the past is how, what you just mentioned, that the judicial branch doesn't have its power to enforce its own orders, right? That you rely on the executive branch to do it. And a famous example that we've talked about in the past is President Jackson saying, hey, okay, the Supreme Court's issued it. It's Justice, was it Taney, issued this order, let him go enforce it. Essentially, it's like, okay, the Supreme Court, good luck with that. Like you enforce the laws yourself. I'm not going to enforce orders from the Supreme Court I disagree with. And of course, Eisenhower famously sent in the National Guard to enforce a desegregation order when the state government was not complying. Here, what we have is we don't have Trump declaring, or even Bovino declaring on the steps of the courthouse, I let Judge Ellis enforce her orders. Good luck, right? We're not going to enforce her orders. We're not going to, but there's like this formalism, like we'll make some well-meaning or complicated arguments in court, but the effect is the same. It's a formalistic pretend compliance or respect, but the practical effect is the same as Justice Jackson thumbing his nose at the
100%.
Supreme Court.
That's right.
Excuse me, President Jackson thumbing his nose at the Supreme Court.
Yes. So, I mean, I guess we're now at the point where, we see whether the Seventh Circuit issues a stay. And then they're going to go up again to the Supreme Court. If the Seventh Circuit says we're not going to stay her injunction, we're going to leave it in place, they're going to go to the Supreme Court. And, we've just been through this chutes and ladders like a million times now. It's just that everything is these emergency orders that try to stop the administration. And I think in most cases, I think maybe except for the one Kilmar-Abrego case, the Supreme Court has essentially taken the position that when the executive branch is unable to pursue its policies or its prerogatives, it is harmed. And therefore, even until the litigation is resolved, we got to let them do whatever they want, even if it turns out that what they've been doing the whole time is not legal. And we figure that out 2 years from now.
Right. And in the meantime, while all of these legal issues are going to be discussed and debated, Bovino and his band of uniformed masked agents are going to travel. Like I said, I think it's Charlotte is what reportedly is the next stop. Now, the DHS claims they're not leaving Chicago, but all the reporters are saying they're all leaving Chicago. It's getting cold here. So we'll all leave Chicago. We'll go to some other circuit, some other court of appeals, some other jurisdiction, and start the process all over again. They can keep traveling around the country. And if there's no prospective way to deal with them on a prospective basis, then courts are never going to be able to keep up.
And not only no prospective basis, but no prospective basis to do it nationwide, because that is the thing that came down after the birthright citizenship case, that, no judge in one place is really able to do anything for a jurisdiction. So we're just back, it's just Groundhog Day, I think.
Right. 100%.
Speaking of Groundhog Day, we'll talk about the Snap case.
Yeah. Now, it's obviously was in many ways an extraordinarily exigent situation. It may still be. We'll see now that the Democrats have caved or appear to have caved in the shutdown. And it looks like that's ending soon. But SNAP, of course, is this is really a assistance for needy families. This is food for people who are hungry. That's what we're talking about here.
Right. And the law actually has a contingency fund to allow SNAP to continue to be funded, even in the event of a shutdown. And initially, Trump administration did not want to use it. That itself is shocking, because I think in the first shutdown back in, what year was it, 2019? They did use it. They did dip into this. So this has become a leverage tool, or a way of, I think, pressure. I think the intention was to just create more pressure for Democrats to concede and cave or whatever. But there is a contingency fund that the administration can use, and even under that, so that contingency fund has about $6 billion. It actually is not enough to fund full benefits under SNAP for a full month. I mean, I don't know why that reserve doesn't have more, but my guess is they probably don't. When it was passed, it probably wasn't anticipated that a shutdown or some lack of funding would extend for that long. SNAP actually needs closer to $8 billion in order to fund everyone in the country for a full month. But there is a second fund called Section 32 funds, and this is sort of a pot of money that is used for child nutrition programs generally. And the law also allows the Secretary of Agriculture to repurpose those funds as needed for other, nutrition related programs. So they can dip into that Section 32 bucket, which has about $23 billion. But the Trump administration doesn't want to do that either.
That's right. And I'm just a quote. This is 7 USC U.S. Code 2250, Section 2257. Not to exceed 7% of the amounts appropriated for any fiscal year. The work of any bureau, division, or office of the Department of Agriculture shall, like any of the expenses, shall be available interchangeably for expenditures and the objects included within the general expenses, et cetera. So this money, you talked about separation of powers before, and I just want to make sure I put a finer point on this for our listeners, that what this is about is Congress passed a law. Okay, SNAP didn't just snap out of thin air. It actually was created by Congress. And these funds were appropriated by Congress because that is how our system works. Okay, that Congress ultimately passes laws that are signed into law by the president, and then they appropriate money. And that money has to be spent. Although I think we've also discussed earlier this year at times, Asha, Trump's taken the position at times that he cannot spend money. Essentially, and he's done this in the CFPB most notably, where he's basically like, you know what? I know Congress has created the Consumer Financial Protection Bureau. I know Congress has funded the Consumer Financial Protection Bureau, but I don't agree with it. So I'm effectively not going to use those funds and effectively nullify a law on my own without taking any action whatsoever.
Right. And thereby neutralizing the essential core function in the legislative branch, which is their power of the purse. So we talked in the last segment about the infringement on separation of powers by the executive branch on the judicial branch, and this is how they do it with Congress. So to bring it back to noncompliance with court orders, in the SNAP case, a lawsuit was filed in Rhode Island, and the judge in Rhode Island initially gave the administration an option to either partially fund SNAP using that $6 billion contingency fund that exists, or to fully fund SNAP using the combination of, the contingency fund and getting the balance of it from that Section 32 fund. And the administration said, okay, we'll do option number one. And the judge said, okay, then you need to do that ASAP, and whatever the logistical burdens are to get this funding out, even partially, you need to figure it out. They're like, okay. And then they didn't do it. And so then he, I think it's a he, had to bring that judge back, bring the administration back into court again. So, it's like it's the same kind of pattern, right? And then issue another order that basically, and the administration's argument was this. They said, well, we've never done partial payments before. And the system isn't set up to do that. So it might take us months to reconfigure, whatever it is, like the payment system in order to reduce every state's funding by 35%. And so the judge is like, well, then why did you choose option number one? Like, in other words, you chose option number one, knowing that you either wouldn't or you couldn't comply with it. And therefore, I am now ordering you to do option number two, which is to fully fund the SNAP benefits using whatever's in the contingency fund, drawing the balance from this other one. And the Trump administration appealed that, again, alleging separation of powers issues, this time saying that the judicial branch, not that they're infringing on the executive branch's prerogatives, but they're infringing on Congress's prerogatives. This is, again, rich. Like, they're saying this court is trying to tell Congress, how money should be spent, and that's not its job. And they also made some specious claims that if they were to dip into that Section 32 bucket, that then there would be no money left over for child nutrition programs for, to use for these other, the kids would be starving, basically, which is false.
Yeah, it's interesting. First of all, this is another judge. This was, I think it was John McConnell in District of Rhode Island. Another judge struggling to deal with, there's definitely a theme here, struggling to deal with an executive branch that certainly appeared to be trying to obstruct his activity and not try to reach an accommodation in his order. And I will note here, one thing that you mentioned, Asha, is potentially putting more pressure on the Democrats. This was the second shutdown, I believe, or the second long shutdown that Trump has had. You mentioned the first one in the prior administration. And part of, I think it's fair to say, what was happening here was these hungry people were being used as a leverage point. Mm-hmm. Okay, let's just call it for what it is. Similarly, by the way, there's been some reporting that what really broke the impasse on the shutdown was, Tim Kaine, a senator from Virginia who represents tons of federal workers, had to deal with a threat from the administration that they were going to RIF, in other words, reduction in force or fire thousands and thousands of federal workers permanently, and that was on the table for the shutdown. And so essentially what he got there was these people's ability to continue employment and feeding themselves and their families. And here, similarly, you have, I would say, people who are hungry being used as a bargaining chip. So in and of itself, time was the point. In other words, choosing the wrong option, creating difficulties. Like, it's often the case that judges issue orders that are difficult to follow, and there's often a back and forth, but usually that's par for the course, and you have a back and forth with litigants about that. Here, though, where the time is of the essence and delay benefits the executive branch in some negotiation, it was entirely the point to effectively create a lengthy delay.
Yes, I hope people understand that this was starving people for leverage, basically. And I think, like you said, to draw the parallel again, is to, kind of have a plausible deniability in the non-compliance, right? We're going to choose this option that has, kind of arguably, plausibly, some logistical impediment to being able to implement it, so that when we get called back in, we'll say, oh yeah, it's the payment system, we can't figure it out, it's just too hard, it's gonna be a while. At that point, you've already wasted like 4 days, right? This reminds me of when they refused to obey Judge Boasberg's order, and they're like, oh well, you said it verbally, but it wasn't written down, and so it wasn't really clear whether you meant it, or I don't remember what their exact argument was, but it's sort of trying to be in non-compliance or being in noncompliance while having some sort of fig leaf to kick the can down the road a little bit.
Right. And particularly where that is the point.
Mm-hmm.
It is often the case that
which was the point in the deportations case too. Is
get them out of the country.
Mm-hmm.
Get them out of the country. And I think the difference here is the stakes. It's often the case, Asha, I'll just say this to give context to our listeners. It is often the case in a litigation that one side benefits from delay and the other side benefits from moving things along quickly. And there's a tension that goes back and forth. And something you and I discussed quite a bit, actually, in the context of the Trump criminal matters before his second election, where there was all sorts of motions and back and forth with district courts on various things. And that's an ordinary part of the process. But in that case, there's so much at stake. And here, what's at stake is immense for the people impacted.
And that order from that judge has still not gone into effect because the First Circuit refused to issue a stay and also said, time is of the essence. You need to, get this in place. But of course, the Trump administration had already appealed to the Supreme Court, which had given some time for the First Circuit to come to a decision because the Trump administration kind of tried to skip over that. And now the Supreme Court has issued an administrative stay, meaning they're giving it a few more days ostensibly so that the political branches can resolve this without having to tell the executive branch what to do. But which, if that happens, I mean, that's great in the sense that people will finally get their funding, but it does reward this whole strategy. I mean, that means that the strategy has worked.
That's right. And just to be clear, I mean, this was, the administrative order you referred to was issued by Justice Ketanji Brown Jackson, appointed by President Biden. And I think it's, reading between the lines, it's fairly clear that she tried to give the First Circuit Court of Appeals, also very stacked with appointees of Democratic presidents, time to reach a decision. And then, she essentially in her administrative order basically said, I'm going to say this for now, but she essentially had like a line at the end that's like, the First Circuit is expected to issue this order with dispatch, it's ruling with dispatch.
Like, get on it.
Get on it. Because I think she knew that the Supreme Court, there was going to be 5 or 6 votes to go with the administration as usual.
Yeah. Yeah. I mean, I guess it wasn't entirely clear to me, like why that, because they're back at the Supreme Court anyway now. And, I guess it kind of bolsters by having the First Circuit back up the lower court, I guess, kind of adds to the record and, emphasizes that this was something that both the appellate court and the district court were on board with. I will just point out another thing that was happening behind the scenes, which is that because the administration is so incompetent and apparently doesn't know how the funding system works, the Department of Agriculture, when the lower court order saying that the government had to fund these fully last Thursday night, I believe the Department of Agriculture assured states that they were going to do that. And I don't know what flip they switched or whatever, but basically there were several states that were waiting to submit their funding requests immediately. And so there's a handful of states that did in fact get full funding for the month of November. Then there were other states that were kind of waiting for the litigation to play out. So they don't have anything. And then I think there might be some states that got, partial because that's all that was left, so you also have, and now the administration, since that happened, was demanding for the states that got the full funding and have presumably already dispersed it, by the way, to the people that need it, was demanding that they give it back. And so I think there's now a separate litigation on that, basically, trying to stop the government from making the states give it back. But anyway, so it's a hot mess all around.
Yeah, I agree. And, this is a hot mess that I think is part of the point. I mean, the
Yeah.
point is to create chaos. I mean, you had mentioned earlier that this has not come up in the prior shutdown for the Trump administration. It's just worth noting also, this is not something that has come up in other shutdowns either. I mean, government shutdowns occur. Usually there aren't massive firings of federal employees. Usually there aren't hungry children who don't have food. And I think that was the point here. That was
Yeah.
the point. So, Asha, before we go, this morning my wife texted me an article that pets take on the personality of their owners. And she claims that Henry, who is, I think I've told you, is a businessman, he's very serious, has taken on my personality as
Oh,
a
really?
result.
Are you
Yes.
a very serious businessman?
Well, in my wife's world, she thinks I'm a very serious person, an
Really?
intense person, because she's like very fun and frolic sort of
Okay.
person.
I mean,
Does
I'm
that
kind
make
of fun
sense?
and frolic, but I don't think you're that serious.
Thank you. I agree. But that is, I'm accused of having altered the personality of our dog, Henry. I'm
Okay.
curious, is Pancake, who I would say it's fair to say is not kind of always strutting around without regard for anyone, is that is that reflective of your personality?
Are you saying I'm selfish? Pancake, Pancake does not regard other people's needs very much, but I think that's just kind of cat behavior. He wants to play all the time. And I think in that regard, I don't know that I'm that way. I have a lot of work to do. So in fact, I feel very guilty because he wants to play constantly. Like that's why when you see him and he's jumping around, he's brought some toy up to me to like play with him. And he's like dropping it here. Yeah. So he likes to fetch hair ties. He likes to play with feather. He likes twisty ties and plays fetch with those. So he's always when he's strutting back and forth, he's trying to get my attention because he's brought a toy to me.
That is interesting. And if you aren't watching our podcast on the Midas Touch Network or the Legal AF part of the Midas Touch Network, you're missing out because Pancake, like literally, Asha will be talking and then like right in front of her face, like on a regular basis, this cat just sort of comes into the view.
And the YouTube people who watch on YouTube, there's always like a contingent that like get really mad about that. And they're like, how can I take you seriously when your cat is in the picture? I'm like, I don't know. Like, it's a cat, lady. Like, what do you want me to do? I'm at home. But yeah, I think that maybe that article that your wife sent you only applies to dogs. Because I will say my last cat that I had for 18 years, I think was a sociopath.
Wow, that's quite an indictment of your cat. I've never heard anyone call their pet a sociopath before.
He was kind of a sociopath. Like, the meme where like the cat is reading the book, like, How to Commit Murder or something like that.
Yeah, that was your cat?
That was my cat.
Wow.
So I love him. I still miss him. But it was kind of an abusive relationship. But I don't think this idea that the pet becomes like their owner applies to cats. That's my opinion. I hope not. Right. I don't think I'm sociopathic.
Fair enough.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.